Today I want to talk to you a little bit about the marriage-based green card and also the K1 visa, otherwise known as the Fiance Visa. Hi everyone, my name is Yalda Hijabi and I focus my practice primarily on employment-based immigration and family-based immigration. In both circumstances, there is some mutual love between a foreign national and a US-based individual. For a K1 visa, the foreign national must be getting married to a US citizen. For a marriage-based green card, the foreign national is already married to a US citizen or a legal permanent resident. So when does it make sense to apply for a fiance visa versus a marriage-based green card? Well, the most obvious answer is that if you're not married, you can't apply for a marriage-based green card. Now, let's say you're starting to bring your lives together and you're ready to tie the knot, but the circumstances in your life has forced you to live separately. I see this all the time with clients where I have a client here and their spouse or fiance or girlfriend is living abroad still. In that situation, you want to apply for the fiance visa because in order to have a valid marriage-based green card application, you need to include what is called bona fide documents. These documents for a marriage-based green card must show that you have had a long-standing and valid marriage between you and the person that you are petitioning for to come to the United States. These documents can include a joint lease, joint car insurance, joint health insurance, joint investment accounts, and you name it. So anything joint. Sometimes we don't have all of them, so we work with what we have. But essentially, you want to include documents that show that you have lived together and that your lives are shared. It's a little different with the fiance visa because for a fiance visa, you just want to include documents that show that you have met at least once, you've been in communication with each other over the years or year or months, and that you plan to get married within 90 days after the foreign national's arrival to the United States. So the rules are a little bit more lenient. A lot of times I have clients where they're ready to move into the next step of their lives and they want to get married abroad and start petitioning for their foreign national spouse. It's a little bit harder to do that because if the US citizen petitioner is living in the US, which is often the case, and the foreign national beneficiary is living abroad, but they're engaged, it's a little bit more challenging to include and provide documents showing that the two have joint lives together and that they've essentially been commingling their lives, their funds, and so forth. So in those circumstances, I've typically recommended for the US-based petitioner to propose to the foreign national girlfriend or boyfriend, however you want to do it, and have the foreign national come to the United States and show proof of them getting married within 90 days. And then after that, they can build their lives, get more settled in, and hopefully be eligible to apply for a marriage-based green card down the line. So while the two are similar in the sense that the core of the petition is that you've fallen in love and you want to be together in the United States, the marriage-based green card takes a little bit more work. And the main reason for that is that it's a green card. So when you apply for your foreign national spouse or fiance and so forth, you're really trying to show to the government on a marriage-based green card case that you're going to live in the United States permanently and you have a permanent intent to stay here. For a fiance visa, it's a little bit different. It's a non-immigrant visa, but of course, with the proper documentation and time, it can lead to a green card for the foreign national. So I hope that was helpful in summing up a marriage-based green card and its requirements and a fiance visa, otherwise known as a K1 visa, and when one should apply for one versus the other. Thank you.